from a disability rights perspective, and this is a workshop being organized by collectives at NLS, including NLS Feminist Alliance, NLS Square Alliance, DA, DSG, and SPAC. And the agenda for today will be discussed by UV. So first, with the speakers. So today we have with us Mr. Rahul Bajaj. Mr. Bajaj is a Rhodes Scholar, an attorney at ERA Law, and a senior associate fellow at Vidhi Center for Legal Policy. He's a distinguished disability rights scholar and activist. He's also the co-founder of Mission Accessibility, an initiative aimed at dismantling the barriers faced by persons with disabilities in accessing apps and websites. Thank you, Rahul, for coming here. Along with Rahul, we have his colleagues, Mr. Turab and Mr. Amar. Both of them are distinguished lawyers and disability right activists. They will be joining us later for the talk at MA later. And we also have in the audience Mr. Professor Dr. Sanjay Jain, who has gracefully agreed to be here and attend the workshop. Thank you, Professor, and thank you, Turab and Amar. I think now we can move on to the agenda. Urvi will be taking over.
Thank you. Welcome, everyone. So today's discussion is going to revolve around basic concepts related to disability rights, such as accommodation and non-discrimination. And also towards that, we are going to be looking at the Supreme Court's judgment in V. Surendranath versus State of Tamil Nadu. So with that, we can begin the session.
Thanks, Urvi and Abhishek. It's great to be back on campus. I taught an elective here in 2020 and 2021, I beg your pardon, in the first trimester during COVID online. So it's great to be back. And of course, I continue to remain connected with NLS through Mission Accessibility because a large number of our student volunteers are second year students here, and you will hear from some of them in the second session. I was asked to speak about disability inclusive judgment writing. I had developed some prepared notes which I was going to consult when talking to you, but now I have decided to just sort of speak my mind based on what the broad topic is, rather than trying to make this a lecture. So I will just spend a couple of minutes talking about some key concepts that it's important for us to remember when we talk about what a disability inclusive approach to judging would look like, and then specifically do a deep dive into the case of V. Surendra Mohan versus the state of Tamil Nadu, 2019 Supreme Court. Which is related to the ability of those with more than 40 to 50% blindness to become judges, and use that case as a launching point to talking more broadly about what a disability inclusive approach to judgment writing would look like. So I would like one of you to tell me in brief what reasonable accommodation means, if you have ever heard about the concept. And if anyone wants to speak, just you could raise your hand, and either Urvi or Abhishek will alert me to the fact that you've done so, and then I can request you to share your thoughts. Could someone tell me what reasonable accommodation means?
Rahul Manhar has raised his hand. I'm just handing over the mic.
Yes, Malav.
Manhar.
Manan. Yes, Manhar.
Yeah, it's Manhar.
Manhar.
Yeah, so
Manhar. Tell me.
So reasonable accommodation is a concept in discrimination law and equality generally, which talks about how it's an principle to make certain changes in structures, process, etc. To accommodate people with special needs.
Right.
So, for instance, providing a scribe in a written examination or providing an extra time in an examination is reasonable accommodation,
Right.
recognizing that people have different abilities and so on.
Excellent. Would anyone like to build on that and share anything more? What I am getting from Manhar is that reasonable accommodation is about making adjustments and modifications to the way things are ordinarily done to make it possible for persons with disabilities to do them also. Would anyone else like to add? No. Yes. Yes.
Hi, this is Astha.
Astha, yes.
Yeah. So I think not just adjustments and modifications, but it also ranges to additional just improvements apart from
Right.
modifying. So this can range from making sure like whatever your um, virtual PDFs or whatever you're sharing is accessible to people who cannot access it. Um, I think it also ranges from just like improving your software and making additional improvements. It doesn't
Great.
stop at adjustments. I feel.
Right. So providing individualized support and modify customization in a given case to suit the needs of a disabled person. Now, can someone tell me what accessibility means?
Rahul, there's one person. I'll just hand over the mic to them.
To
Uh,
Yeah, mm.
yes,
So
Masoom.
basically, accessibility is a broader concept. If we see and analyze through, draw the contrast between accessibility and reasonable accommodation. So reasonable accommodation is basically individualized support, and accessibility covers the broad range of accessing something and making infrastructure and environment and attitude, all other aspects reachable and like that can be access inclusive.
Excellent. Thank you so much. So the key difference, as remarks by Manhar, Astha, and Masoom make clear between accessibility and reasonable accommodation is this. Accessibility refers to ex ante adjustments that are made to the built environment, to ICT infrastructure, to transport infrastructure, to make it disabled friendly. It is not concerned as much with providing support in an individual case to a person with disability to meet their additional needs. On the other hand, that is precisely the territory of reasonable accommodation, which is to say, beyond making sure that the broader environment is accessible, in a given case, how do we meet the needs of a particular disabled individual by providing them the additional support that they need, that is reasonable accommodation. Now, three other quick concepts I just want to go through, and then I will talk about this judgment. Indirect discrimination. Can someone tell me what that means?
Yeah, this is Asta here. So, a basic concept of how indirect discrimination would work is that the law on the face of it is neutral, but then ends up discriminating um, to certain people or genders or people with specific abilities as such.
Right. So the provision, law, or practice, the PCP as they call it in the UK, provision, criterion, or practice, is facially neutral. It's not designed to discriminate against anyone, but the consequence of the way it operates is that it ends up discriminating against a particular population group, a particular protected characteristic, as we call it in discrimination law, based on a particular ground of discrimination. Can someone tell me what intersectionality means? Ideally, someone who hasn't already spoken yet.
My name is Akshat. So uh, basically, the concept of intersectionality says that people are not just one singular identity. So this was introduced by Kimberly Crenshaw, and she says that people stand at intersection of multiple identities. So a person may be discriminated against or disadvantaged not just because of their gender, but maybe also because of their race or caste. So this intersection is what the discrimination law should ideally remedy.
All right. And then finally, what does ableism mean?
So I think Rahul, ableism is linked to the ignorance of law and policy, or even individuals to the abilities of others and failure to recognize this intersectional identity of others and accommodate it.
Others in general or persons with disabilities
No,
in
any individual, not others. Any individual who's like, everyone
particular?
has different identities. So the failure of law to acknowledge those identities and accommodate them.
Yeah, I mean, that's a much broader issue, but specifically ableism is
Ab-
that
Ableism is linked to disabilities.
that's right.
Yeah.
So the inability to recognize the discrimination, marginalization, the failure to accommodate, to provide an accessible environment to the disabled, all of that falls within the ambit of ableism. Very well. Now we will just can someone just quickly tell us what the facts were in V. Surendra Mohan versus State of Tamil Nadu? I believe Abhishek would have circulated the judgment for your reading.
Sir, may I? This is Urvi.
Urvi, yes, please.
For that, a judge from Tamil, there was vacancy for the post of a civil judge, and a person he applied for this post, but he was not given the post on the fact that he was 70% blind.
Mm-hmm.
But and this case went to the Supreme Court,
Mm-hmm.
where uh, they upheld the policy that wouldn't post above 50% of ability.
Okay. Does anyone want to add anything to that?
Yes, 1 minute.
Yes.
So just to the conditions that the law use. So the law provides that if it's a fall within the 40%, case of disability, that person would be given reasonable accommodation and would be eligible for the participation. Whereas since the volunteer exceeded that limit, he was denied place in the judiciary there.
Right. And what was the basis for the Supreme Court's conclusion that his denial was proper?
So I think one condition which, while he was giving the exam as well, the appellant, he was asked to write, put in an attest, was that whether he'll be able to discharge his duties as a judge with his disabilities. So I think that was one of the reasoning which the court adopted, that because the person has 70% disability, then he may not be able to discharge his duties as a judge.
Right. And why not? Could someone else maybe take that on? Why did the court say that someone with more than 70% blindness cannot discharge, not more than, but 70% blindness cannot discharge the responsibilities of a civil judge, junior division?
So this is Vibha. I think
Yes.
the reasoning that the judgment gave, the two-judge case, is about the nature of judicial function, and they said that a
Mhm.
judicial officer in a state has to possess reasonable limit of the faculties of hearing, sight, and speech in order to
Reasonable amount of.
Yeah.
Yeah.
in order to hear cases and write judgments, and
Mhm.
therefore the stipulated limit of 50% is a condition that's eligible and is a legitimate restriction.
Right. And what is the problem with that actually? In light of what we have discussed, the concepts that we have discussed. Maybe after, towards the end services. Okay, okay, yes, please. Uh-huh. Mm-hmm.
Or increasing.
Mm-hmm.
So he was saying, like, what is the percentage of blindness, vision, which would entitle particular person to be partially blind? So he was not
Which
very.
judge, sorry?
Justice Ram Subramanian in
Okay.
Supreme Court, while evaluating the definition of blindness, partial blindness, he was not comfortable with the overbreadth, as he called it. And he would say that anybody from 40 to 99% may be partially blind, and therefore he was not comfortable with the definition of partial blindness.
Mm-hmm.
And secondly, I think to draw a conclusion, he used his personal experience
Yeah,
with his own
that's I
with his
mean,
own colleague,
yes,
which
yes.
is very unusual and
Mm.
very unbecoming of a judge to do in a judgment. And I think that is the hallmark of the judgment, using your own personal experience
Right.
and then drawing a conclusion that, okay, entire disability community or entire blind community
Right.
is useless to become judge, right?
Right.
Yeah. Apart, I think other things are very well said.
Thank you so much, sir. Would someone just like to develop the second point that Professor Jain just flagged, which is about the can you tell me why it is a problem to extrapolate based on one individual experience that this judge would have had of a disabled person, and on the basis of that to make this broader conclusion about the disabled as a class? Can one of the students take that on?
Yeah, hi. So my name is Chayan. So,
Sayed,
yeah,
yes,
Chayan.
yes.
So one of the cardinal reasons why such an extrapolation is fallacious is that it's a limited understanding, right? So what you see in one example may not cover the lot of people out there who can or are better able to discharge such faculties of a judge. The second
Mm-hmm.
example, the second reason why such an extrapolation is fallacious is that uh, so using any sort of personal experience in a judgment is against principles of judicial writing, right? So, so yeah, those are the two reasons that come to mind.
Hmm. Hmm. Is that so though? The second point, like, let's say, mm-hmm. Okay, right, yeah, right. So the point really being that you can't encode your own prejudice, you can't give voice to your own prejudices and biases, and have that be one of the bases for arriving at a particular judgment. And to the extent that that is what Justice Ramasubramaniam did, it is problematic. Is that correct? Okay. Uh, if he had had a positive experience though of having a person with a disability, I mean, this is a bit of a non sequitur, but I do think it's important, so I'm just going to take 30 seconds on it. If he had had a positive experience of having a colleague with a disability or a law clerk with a disability, and if he had cited that in the judgment, how would you have felt about that? And why would that have been different?
Right. So two responses to that.
Yes.
Again, using such a extrapolation on simple numerics is wrong. So if you see a person
Yes.
in your life,
Yes.
may him be any sort of ignoring his capacities, right?
Yes.
You extrapolate in that in your judgment
Hmm.
simply on the numerics of it is wrong, because the whole idea of writing a judgment is to consult authorities, right?
Uh-huh.
So you have to cite varied sources to come to your conclusion. And personal experience, be it in any form, cannot be considered to be a valid source to arrive at any judicial decision.
By
So-
the way, my recollection, and Professor Jain will correct me on this, of the facts is that the government of Tamil, the TNPC, which was the appointing authority, they were given this reason by the Tamil Nadu judiciary that once we had this person who had 100% blindness, and because of all the problem that arose by virtue of having him be in the judiciary, he had to be reassigned to the Tamil Law Journal, and therefore we feel that this limit is appropriate, is my recollection of how that fact became material. It's not really that Justice Ramasubramaniam out of his own, like, went out of his way in the judgment to say that, look, I once had to supervise this person and this happened. Isn't that right, Professor Jain? Yeah.
Oh, yeah.
Yeah, that we can say. That we can definitely say, but it's, yeah, yeah. Hmm. Right. Right. Yes. Yes. Right.
Yeah,
So
exactly
you were
my
saying
point.
something.
Yes.
Just finish your point, please.
Yeah, so exactly my point. So deriving on judicial decision, on your personal prejudice or bias, on the pretext of you seeing somebody X.
Yeah,
who-
that's your first point. And you
Yes.
said there were two things you wanted to say.
Yeah, so the second point was simply the numerics of it.
Got it.
You've seen one person. just-
Understood. Understood. That point is well taken.
Yeah.
Okay, very well. So now, what would an alternative version of such a judgment look like? I mean, I want to hear. I mean, of course, I may share my thoughts, but like that's sort of. I mean, I can do that at the end. Maybe I take a couple of minutes to share what the key strands of the rewritten judgment of this were. But I am bored of hearing my own self talk about it. So therefore, I want to hear it from you. So you tell me, according to you, what would an alternative version of such a judgment look like? What would be some core ideas that it would be based on?
So one thing that I have difficulty understanding is why
Yes.
is the law so obsessed with reducing disability to a percentage? So in this case as well, when the appellant is arguing, the appellant's
Mhm.
counsel is arguing that the person, even though the person has 70% of disability, he falls within the definition of partial blindness. So
Right.
the court comes up and says that this partial blindness, it may be a general term, but as per the rules defined, this partial blindness is only between the 40 and 50%. So my understanding is, why are we so obsessed with classifying disability on the basis of percentages like this?
Yeah, absolutely. That point is very well taken. Now, I would like you to go one step further and tell me how you would express that in a rewritten judgment. Like, how would you make that point in the context of this particular fact situation? Because that's what judgment writing is about, right? It's not about abstract ideas, it's about dealing with a particular fact situation in a given case.
So
Yes, I will come to you. Who is that? Yes, I'll come to you. Sorry, I still haven't gotten your name. What? Hmm. Chayan, okay. So I'll come back to Chayan in a second, but first, is that Akshat who's speaking?
Yeah.
Yes. Hmm.
So my, like, on the question of what partial blindness means, my interpretation would be that we need to take partial blindness for what it means in general rather than affixing it to a percentage. So
Okay.
in that sense, even the appellant here, even though the person has 70% of the blindness, that person will also be covered under the ambit of partial blindness, and
Okay.
hence the remedy should be given to him.
That, I mean, I'm not sure that I follow your point. So you're saying that, look, the ceiling here, the impugned ceiling was that you have to have no more than 40 to 50% blindness, 40-50% it says, in order for you to be eligible to become a civil judge junior division. And this individual, Mr. Mohan, his blindness was 70%, right? And you say that, look, you can't be obsessed with percentages, which point I absolutely agree with. But then what do I do as a judge with that ceiling? What do I say specifically?
I think then it would be that you should have no such ceiling.
So then what do I have to say in the judgment? Like, how do I write it? Chayan wants to chip in. Maybe a bit of a challenge for people to run around with the mics, I imagine, from one side to the other. Yes.
Yeah, so 2 points to that. I don't
Mhm.
think that classifying disability is a wrong premise altogether. So you can classify disabilities in terms of percentages
Mm-hmm.
in order to analyze or understand
Yeah.
what reasonable accommodation is required to that
Uh-huh.
specific disability.
Uh-huh.
So a person with a 40 to 45%, sorry, 40 to 100% disability
Uh-huh.
will require a different set of uh, operate or like procedural or
Correct.
any other faculties to assist him
Mm-hmm.
than or as opposed to a person with 0 to 40%
That's
disability.
right.
So that's the first point.
Uh-huh.
So my problem here is in the way the judges used such a numerical classification
Yeah.
to come to a conclusion.
So that's what you would say in your judgment, right? You would
Yes.
say that this impugned
Yeah.
ceiling has to be struck down.
Yeah, and scientific the way in which it is done should be struck down.
Uh-huh.
The whole idea of classifying should not be struck down. The classification should remain,
Uh-huh.
but it should be dedicated or directed
Right.
to arrive at a uh, a uh, a solution to reach
Uh-huh.
a solution
Correct.
to get the accommodation so required to that particular numerical bracket of disability in order
Right.
to assist that person to carry out
Very
or
well. So you
discharge.
would say that, look, the answer to someone with 70% blindness can't be that
You
because
can't
your
do it.
blindness is more than 50%, we will exclude you. The answer has to be, we'll provide you more reasonable accommodations to offset the impact of your disability vis-a-vis
Exactly.
someone whose disability is only 40%, correct?
Right. Yeah.
So what model of disability is that approach grounded in, actually?
Ableism, I think.
No. This approach, what you are suggesting, and I am sort of reformulating, what model is that grounded in?
So that's, I think, reasonable accommodation
Yeah.
only.
So what model of this? So there are two models. Does anyone know? Like commonly, of course, there are maybe more, but the two commonly understood models of disability, what are those actually?
I'm not aware.
Sorry, someone said medical. That's correct. Who's that? Yes, thanks, Masoom. So medical and social model. So this approach that you are suggesting, what is that grounded in actually? Is it? Yeah, but the idea of providing reasonable accommodation to deal with this rather than just excluding someone because their percentage is high, why is this actually rooted in the social model?
So I think it's an intersection of both.
How so?
So a person might require both types of medical and socio-economic accommodations to
No. It's not about the type of accommodation you would require. The whole idea.
Yeah, I get it. The approach is right. So I think yes, I still stick to my stand that they might be an intersection of both. So if you say that I'm only giving you one approach that is socio-economic,
Okay.
to cover all your reasonable accommodations, I think that cannot be done. So
okay. Anyway, I mean, you wanted to make another point also. You said there were two reasons that you would strike this down. What was the second one?
no, that's the classification
That
should
it
be
shouldn't
reversed. Yeah, it should be done to achieve a positive motive.
Understood.
Than
Okay, very well. So that's one strand of the revised judgment to say that we would bring in the idea of reasonable accommodation and say that, look, because it's more than 50%, you give more accommodation. What else would a written version of this judgment in light of our discussion look like? I mean, tomorrow, let's say there's a case that I am involved in right now. Okay, I had a meeting about it just 2 days ago with the government involving the exclusion of those with disabilities from the IPS. Like there's an absolute exclusion that if you are a disabled person, you cannot occupy any post in the IPS whatsoever, right? Is that okay according to you? And if not, why not?
Hello, sir. This is Ayushi.
Yes.
Sir, with regard to the question you previously asked, like I wanted to answer
Yes,
that.
please.
Sir, with the fact I have a major contention with the judgment. So the appellant also argues this.
Yes.
He says that the 1995 Persons with Disabilities Act
Yes.
does not define any percentage there.
Hmm.
And it is a additional regulatory measure that has been brought by the Tamil Nadu Public Service, if I'm right.
Hmm.
So, and what is the empirical reason as to why is only 40 to 50% being considered
Right.
is not explained. So I think that is done by the government in many factors. Like in the EWA judgment, also the court asked that
Hmm.
what is your empirical basis to have 8 lakh rupees as the basis. So even
Mhm.
here there is no basis for 40 to 50%. The court is just assuming that a person with 70% disability would not be able to work as efficiently as the person with 40 to 50% disability.
And what is that actually? What is the term for that? No. They're like just having this assumption. Yeah, that's the legal term for those with more than, but like this assumption that okay, those with more than 40 to 50 cannot discharge. What is the word for it? No,
Ableism?
stereotype.
Stereotype,
It's
yeah.
a stereotype, right? So it runs contrary to what is called the anti-stereotyping principle. Does anyone know about this by any chance? What that means?
Yeah, so basically, I'm martled, by the way, and essentially,
Sorry, you are?
martled.
Yes.
And so the anti-stereotyping principle, as I understand, is essentially you do not reduce people to their marginalized characteristic when trying to, especially using constitutional law, I think, and when you're working on discrimination and stuff like that, you don't look at it from the perspective of everybody from a particular marginalized group acts or behaves the same way.
Right. And sorry, are you okay? Thank you for that, Mathur. You said your name was.
Martled.
Yes. Yes.
Yeah, actually, Tamil Nadu Public Service Commission has completely excluded blind people. And then court posing paternalism said that okay, we'll do one thing, we'll make it to between 40 to 50%. So court is sounding very paternalistic. So in fact, court is trying to be accommodative in saying that okay,
Is that so, sir?
Yes.
My understanding was that the commission
No.
itself had imposed that.
No. The ceiling was imposed by the court, 40 to 50%. This is an invention by the Supreme Court, the two judges, if I remember correctly.
No, not the. It may be the High Court at best, but surely not the Supreme Court, because the Supreme Court was only called on to decide whether that ceiling was appropriate. My recollection is that the commission had come up with it,
No,
but
we can find out.
But
As
let's
far
find
as,
out.
as
Yeah.
far as I remember,
Yes.
Even the ceiling is suggested by the Supreme Court. And if I remember correctly, Ram Subramaniam, after complaining about the definition of partial blindness, he said that, okay, fine, we'll make it from 40 to between 40 to 50%. But you can find out the
Yeah.
number
This we'll check. I'll come back to you on this. But Ayushi, you were saying something. Did you have something to add?
Yeah, so regardless of the assumption being so,
Yes.
I would say that firstly, on a legal measure, I would consider the definition that has been provided by the Act. So additional regulatory measure introduced by the government without any reasoning, the court should not consider that. And also, I was confused in the judgment with regards to why there was this issue that they did not allow the appellant to appeal under because he did not appeal under a certain notification dated 26 August.
Yes.
And they dismissed that. And I could not find any reason as to why they did that, because he wanted to amend his petition. And
yeah, he wanted to challenge the ceiling itself, right?
Yeah, sir.
Because his rejection, he was told, was ground. So there was a letter, I think, of 8th August, by which he was told that you will not be selected by virtue of this earlier notification. So he wanted to amend the petition to challenge that ceiling itself.
Okay. Yeah, so and so just like sorry for elaborating it, but just a trivial addition. I also feel that the High Court allowed the appellant to participate in the interview, and they did not let the results out. They said it would be in the sealed envelopes. Like why? Why was that so? Because I don't understand any reason to do that. Because if yeah, that's all.
Right.
Thank you,
Right.
sir.
Okay. So, in the interest of time, because we also have to pivot to talking a bit about mission accessibility in a couple of minutes, I'm just going to tell you what the 4 or 5 core principles that my rewritten judgment were based on. And I have asked Abhishek to circulate a copy of it to all of you. So, please do read it at your leisure, should that be your leisure reading. One is that it's contrary to the anti-stereotyping principle, and it is based on noxious stereotypes about what those with over 40 to 50% blindness can and cannot do. Second is that it's contrary to the principle of reasonable accommodation for the reasons that we have discussed, because it absolutely doesn't look at that idea at all when evaluating this ceiling. Third is that it does not take into account the fact that those with over 40 to 50% blindness in other jurisdictions, developed and developing, have successfully discharged the responsibilities of a judicial officer despite their limitation. So therefore, it's not attentive to that reality, and the march of technology which has made this possible. Fourth, that it is violative of the dignity of those whose disability is over 40 to 50%. And I explain why their dignity is violated, because it stamps all of them with a badge of incompetence. Of course, human dignity can't be looked at in isolation and should be seen as one of the strands of a multidimensional approach to the issue. More on this in the rewritten judgment, which I would suggest that you look at. And the overall approach that I take is grounded in substantive equality rather than formal equality. And I point out how this case at bottom raises a conflict between those two conceptions of equality. And the one that I support is substantive equality, which would be rich enough to allow for concepts like reasonable accommodation, and as well as accessibility, actually, because in the first place you need to make your court environment accessible, and then you need to accommodate those with particular disabilities in given fact situations. And also I talk about how this one last thing and I'm done, with respect to this example of this one person who wasn't successful. Two things, right? One, you can't just stop at saying that, okay, we had this one person who was rubbish, and therefore we had, I mean, who couldn't cope, not was rubbish, but who couldn't cope, and therefore we had to put him elsewhere. I mean, you have to ask a whole host of questions. Why did that happen? What support was provided to him? Could more have been done? The blame for that has to lie at the doorstep of the court system also. Why can't they take steps to accommodate someone with a disability? I mean, is it only the person's responsibility? So the system has to take some responsibility also. And the second thing is, it reminds me of what Ruth Bader Ginsburg sort of used to say about being denied employment when she was trying out of law school and was trying to gain employment in the early years. And someone would say, oh, we hired so and so woman and she was rubbish, so we won't hire you. And she would think to herself, well, how many men did you hire who were rubbish also? So just because you had one person, who wasn't good enough or who couldn't do the job, based on that, it's very unfair to paint the entire class in that way. All right, I'm done now. So now we'll really pivot to talking about mission accessibility. And what I propose to do, I mean, first I'll just ask Amar and Turab, who are co-leading this with me, if they want to share a couple of words. And then I really like those who are in this audience, our volunteers, to share their experience of working for us, because as I said, we have a large volunteer pool that is based at NLS. So first, Amar, would you like to say something? I'm going to just observe in this session.
Hey guys, great to be back here after 3-4 years. Some of you did speak about accessibility, but I do feel from the interaction that the understanding about accessibility is limited. What is accessibility according to you?
And I don't want, the typical, the stuff that you would have read. Give me a practical example of what accessibility means to you, or inaccessibility for that matter.
Am I audible?
Yes.
Yes, I'm safe. I think one way of seeing accessibility is to first identify the axis of disadvantages for anyone.
Okay.
For example, if a person is visually impaired, and that axis of disadvantages for him in comparison to his peers and other colleagues is that he's not able to access the documents, he's not able to, visualize the question paper and write the answers on itself. So I think something like a scribe or something as digital accessible, PDFs can help to him. So I think this can be applied across all the spheres and all the classes who are disadvantaged. So I think like identifying the axis of disadvantage and remedying it is something I believe is one of the, the course you take.
So, Saif, you're 100% correct, but I want to hear a real life example that you can practically think of how it, see, not being able to read document is something you can understand because you have been working with us possibly and you have that exposure. And I want to touch upon people who are not our volunteers, but how do you relate to this problem? That's my main concern, and I'll be done in a minute. Just give me one real life example.
Hello, sir. I'm Prajwal.
Yes.
So on the campus, we have two academic blocks. We are currently in the old academic block, which has a lift and has 3 floors. And the new academic block also has, it has 2 floors and has no lift, but does have a ramp to get to the ground floor because of the stairs. So considering the fact that the old academic block was constructed quite some time ago, there was initially no lift also at this place. So it was so some of my friends told me that they understand the value of the lift when they actually get a leg injury or something.
Okay.
In that instance, they understand how they can actually, because that so this Professor Sarsu told us in one of the courses that earlier when there was no lift, if any person in the class injured their leg, they had to shift the whole class to the ground floor because there was no way to get up to the other floor. Okay. And that problem persists. So this is, I don't understand how that happened, but the new academic block, which has been constructed right now, with all the conversations around accessibility going around, we still do not have a lift there. And there is no ramp to get to either the first floor or the second floor or anything.
Okay. Good example, Pradwan. I'll just take a minute. So basically, okay. अब मैं इसको बहुत real life example से I'll connect it with a very, very real life example. And I'm going to ask a very sensitive question, okay? Because I want to make it very interactive. I want to hit your hearts by saying this. For how many of you, an unplanned pregnancy would be a private affair? I'm sure for everybody, right? Is there anybody who would want to say no? Then say yes, guys. Correct? Now, and how do you initially, when you go to test it, you use the kit and you test it, you get the results. Now think of it in a blind person's context. A blind girl or a female wanting to test it, she won't be able to see the lines drawn on the kit. It's a very sensitive thing, but I'm just giving you real life examples to connect it to your minds that whenever you think of anything, think of it how people differently are going to use different services, products that we use in our day-to-day life. Okay. So a blind female wanting to test her pregnancy will have to divulge this information to somebody to be able to check what the result is, correct? Do you guys relate to it now? The medicine package that we get, the medicines, the tablets are completely, it's all, whatever is written is visual. They don't have a fixed QR code where you could scan and get the information as a blind person. Right? How would you identify which medicine I have to take when? Shapes is one example. Shape, okay, you can say, you can look at the shape, whether it is round, whether it is square, whether it is like this, like that. That's one example. But is that a reliable method to do? No, right? So accessibility is all about usability. Whether as a person, I'm able to use a particular thing or not. Are we thinking of everybody when we are designing our products or services? That's the key that we need to keep in mind. So when, as lawyers, you are designing your policies, one thing that we should do as part of your procurement, make sure in the companies, wherever you guys work, as a law firm lawyers, wherever, whatever profession you choose as lawyers, make sure that we will prefer an accessible product over an inaccessible product, right? That is the benchmark that we need to set. And that is how you should think of accessibility. See, apps and documents, why I don't want to give you those examples, because if you have not seen how a person with disability operates computer, how a person with disability operates smartphone, you may possibly not be able to relate with that. But you can certainly relate with the examples that I gave you right now, because these are real life situations that we face on a day-to-day basis, right? If we are able to think in everything that we do from perspective of whether the whatever I'm doing today, if I'm asking for a signature on a paper, do I have alternate means for people who can't use the pen sign? There are people. I use thumb impression, but that does not make me illiterate, right? Because I prefer that. That's firstly, that's in my control. That is not inconsistent. That's doable by me. Right? So do we have alternatives? Anything that you do, anything that you design, wherever you upload pictures on your Facebook or Insta or whatever, right? Do you give a description to it, a meaningful description? What if I become your friend today on Facebook or Insta, will I be able to follow your post if you just upload the picture? No, right? Because I won't be able to see the picture. If you just spend good time with Amar Rahul Turab at NLS today, a selfie uploaded, whatever. I mean, the fact that you uploaded a photo needs not to be mentioned, but the fact that this photo is about this particular purpose, just writing that one step, taking that one additional step, can make your life, our life, everyone's life more inclusive. I think I'll just end it here. I just wanted to set this context in your mind, how to think about accessibility. A washing machine, completely touch-based washing machines. You know, I just recently bought a LG washing machine, which is Wi-Fi enabled, and I can simply use it on my smartphone without having to rely on anybody to press the start button or anybody to press anybody to select the different washing cycles. Just imagine how inclusive, designing can make things accessible and usable for everyone. That's how we should think about accessibility. I'll just end it here. Turab, do you want to add?
Yeah. Hello everyone. Nice to be here on campus. It's my first time here. I mean, like enough has been said, and Amar has covered great points. I only want to acknowledge our volunteers today because there are other students as well. So they obviously learn a lot, and there are advantages of working with us, and they learn from Amar and Rahul about law and various opportunities. But still, of thinking of causes which generally other people don't think of. So to take up this cause and to be sincere about it since 1 year, I really appreciate them. That's the only thing.